Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about real estate, everything from the buy, the sell, to the closing, and hopefully everything goes well with that procedure. Joining me once again is my co-host, as always, Jesse Barrientos. Jesse, how are you, sir?
I'm doing great, Dave. How about yourself?
I'm doing good. Good to see you.
You as well.
Nice summer day here outside of Chicago. The real estate market is starting to bubble up.
Yeah, we get to do our spring kind of real estate show
Every
here.
year we do it.
Yeah.
And this year seems to be a little bit more optimistic than most.
Yes.
Things are moving quickly. The listings aren't lasting very long. You need a good broker. You need a good attorney. You need a good lender. You need the whole package to put together to make sure your real estate transaction goes successful and smooth.
Sure you do.
Let's start with the basics. Let's talk about the contract, correct? Or do you want to start with the listing?
Let's start with the listing. I mean, it depends if you're the buyer or seller. I know sometimes
We're buying.
we're buying,
the
so
buyers
that's good.
today.
But I just want to give a shout out to sometimes people do things by owner, which is you can do that, but enlisting a good realtor and making that listing is might get your house sold quicker. Might not. I mean, hey, you could always try. It's no problem.
Not only that, if you're selling by owner, you don't always have access to the multiple listing service. So I think you're doing yourself a disservice by not hiring a quality broker. I think it's well worth the money to have your property marketed properly and have the assistance throughout the procedure.
Yeah, and you can also negotiate. And again, even though we're doing a buyer's side here, but for the seller, you could certainly negotiate whatever the realtor's rate is. I mean, that
Right.
goes both ways. It's a competitive market.
And the great news for the buyer, great news is the broker is not coming out of their pocket.
That's correct.
The buyer's agent it's not costing anything.
Right.
So you
Everything
might
is-
as well take advantage of that great expertise and that licensed person who can help you.
Yeah, exactly. So as from the buyer's side, you could have a real estate agent or not. I mean, I know a lot of people who have just come by and they've seen a sign or something, and then they go and want to look at it. But if you're really looking for something special in a specific area, you want to get that real estate agent who's familiar with that area. You don't want to get somebody maybe who's from downstate, okay, to buy something here in the western suburbs.
Right.
You want somebody who's familiar with those properties and kind of has his finger on the pulse there.
Right. I believe the agent is an invaluable person in the real estate transaction. So let's talk about the buy. Someone starts with the broker or the agent.
The agent, you come on over, you show me a house, and hey, maybe this is the house, kind of like it. We've looked at a few. This is the one I want. So the buyer is going to tell his agent, hey, look, we've looked at them. This is the one I want to come in. And again, when you have a quality real estate agent, he can give you an idea in terms of, hey, where the sellers are, how long the property has been for sale, because the longer it's been for sale, it gives the buyer a better opportunity because the seller wants to sell it even more after that time. And so what's going to happen is you're going to make an offer. And the offer consists of the contract. And they have these standardized contracts. They've got the multi-board residential real estate contract, 6.1 or higher. I'm not sure if they've got higher than that at this point at the running of our show. But it's important to have what's updated because the terms of the contract are tweaked as the law kind of changes and evolves a little bit. And so it's important to have something that's
And we're going to go through a lot of those terms.
Yeah,
but let's
yes, we are.
start with the offer. What's the one thing, Jesse, about the offer that cannot be changed?
The one thing, which is in the contract, is the price.
The purchase price.
The purchase price. When you sign a contract, and generally and typically the agent will fill it out, will give you the contract, will go through everything with you and tell you, hey, look, you want to have a great kind of impasse on the seller. So here, look, show them you're serious. Larger earnest money. So depending upon the price, it'll be $1,000, $5,000, or even more.
Okay. For the viewer's education, what is an earnest money deposit?
Earnest money as deposit is a sum of money to kind of secure the contract while it's still going through negotiations. We'll talk about the attorney review and the inspections provision. And what happens is that money gets placed with the broker in an escrow account.
Yeah. You actually, very importantly, must put something down in earnest money. Otherwise, there's no consideration, there's no contract.
For your contract,
So you have to put
exactly right.
something down. In addition to good faith, you have to actually have a valid contract, which is offer, acceptance, and consideration.
And then sometimes the contracts provide for a second deposit of earnest money after the date of acceptance.
Okay, so an increase once the agreement is solidified.
Exactly. So what you have here is an offer and acceptance. And so we're writing this up. I'm with my real estate agent, and we sign everything, and it's dated today. Or let's just say today is May the 20th. And so then what happens is it gets sent to the seller's attorney, and the seller looks at it, and there might be some negotiation. It might be on the price. The seller's realtor might come back and say, hey, look, it's a little low ball. They're not going to, before they even sign the acceptance. And so that gets tweaked a little bit. And so after that, let's assume everything is okay. Then,
Wait, so the seller hasn't made any changes? They've just accepted this offer?
right, for the purposes of our demonstration, our example here, but sometimes they could say, hey, you know what, we're not going to accept it. It's a little low ball offer. And a lot of times people do that. They do high ball and they do low ball.
I think it's important for the viewers to understand that if the seller makes a change, any change to the offer, it's technically now a counter offer, and the original offer is gone.
Right, but what'll happen is it'll go back to the buyers, and they'll look at it and they'll initial it, and so it'll be they'll kind of escape that offer counter offer. But we're going to get to that in a second.
But the buyer can now say, "I'm out.
Certainly,
you didn't
the buyer
accept my
can.
offer. You came up with some kind of change. You know what? I really didn't want this house. We saw something else in the interim. We're going to just walk away because you haven't accepted the offer. You countered, and we're not accepting your counter." I think that's an important.
That's true
feature.
too. But in the new contracts, the buyer's attorney has the option of declaring the contract null and void without really anything else. It's in the term of the kind of multi-state or multi-board residential real estate contract that allows them to do that. That's one of the things that have been tweaked. There was some case law trying to say, okay, you can only do that under certain circumstances, but that's all taken care of in the terms of the contract. Again, it keeps on getting better to fit what the law actually is.
Okay, so seller has accepted now.
So seller has
What happens
accepted.
next?
Okay, so now what happens is that the buyer has 5 days for attorney review, and it's from the date of acceptance. So in the example, I think I said May 20th. So let's just say that the seller didn't accept it until May the 25th. Okay, well, it's 5 business days from that date that the buyer now has an option to do the attorney review provision.
Let's hope the buyer already has an attorney retained, so they're not scrambling looking for one during this 5-day period. Correct?
Exactly. If you're willing to make an offer, now a lot of times a real estate agent will recommend an attorney, and that is what it is. Or if you want to do a little kind of research ahead of time and talk to your friends, talk to people who have been satisfied by somebody who does real estate all the time, that's something that, like you said, you want to have in your back pocket. You want to have that all ready to go.
Part of that team that I mentioned.
And in fact, it goes on the contract. You write on the contract on the last page, I believe it is, all of that information. So you really need to have that ready to go when you accept the offer. You don't have to, but boy, I tell you, it certainly is advantageous.
Okay. Next step.
Well, once you do that, and let's just go through really quickly, you have the contract, okay? And then you also have disclosures. I know we're going to talk a little bit more about that, but we have the residential real property disclosure report, all right, which basically is the seller making representations that, hey, listen, things have been done or haven't been done, or he's aware of certain defects in the property, or he's not, or it's not applicable. And you also have the lead-based paint disclosure, and generally that's any property built, I believe, before 1975 has a real danger of lead paint. But hey,
Especially for children.
Especially for children.
Because it's actually sweet.
Well,
Sweet to the taste.
Children put everything in their mouth, and probably the parents aren't going to eat it, or the adults if they don't have any kids. But hey, if you have people coming over, or if you have pets or anything like that, that's also a possibility. And you want to make sure that you check it out. It could be that it was built after 1975, but perhaps they had a test and there was some lead paint, or for some reason. Then you also have the mold disclosure. Mold is a big thing. Boy, it was really new in the day. I don't know how many years ago that was, but hey, it is really dangerous for people. It really affects your respiratory system, and everything else can affect your health, the health of your kids. This is where you're spending most of your time in this house, and then where you're going to sleep, okay? So, 8 hours, depending upon how long you sleep, Dave. I don't know about you, but, I certainly don't sleep that long.
No.
And so you want to make sure that you have that. And the disclosure report is them pretty much saying, hey, listen, they're aware of it or not aware of it, they had a report or they're not, and it's incumbent. We'll get to the inspection in a minute. Then we have the radon disclosure report. Now, radon is a radioactive gas that naturally occurs, and it causes lung cancer. And so, again, it's naturally occurring, especially if you have children. Even if you don't, but especially if your children's bedrooms are going to be, and it's usually in the basement, going to have that. Yeah, I know.
Well, you're scaring the heck out of me. First of all, the house is defective. Then it's got mold.
Well, it's not defective yet. These are
then
disclosures.
It's got lead paint. Now it's got radon. I don't want to live in this house.
Well, you may not. And so once you
heck's
have
going
the
on here?
disclosure says, hey, I'm aware of it, I'm not aware of it, or perhaps maybe when the sellers had purchased the house, they had a radon test and they found out that it was. If there is radon in the house, there is abatement measures that can be taken.
Okay.
And so we're going to get to those now under the attorney review provision. There's two provisions. Again, you have 5 days for the attorney review provision, and you can modify anything except for price. Then there's also the inspection provision. So you also want to have a good idea on an inspector when you start looking for the house, so that you don't waste any time in that.
So we have some strict time frames, and if you blow those time frames, it's too late.
It's too, or the deal will
Like
go
if you don't
south.
have it inspected in that reasonable period of time,
Well, then you waive it, or you could request more. But now we're getting to that offer, counter offer, and we'll talk about that in a second. So you can change anything. There might be some terms that you want to change in the contract, or that you want to add to it, some specific terms based upon the disclosures that you've received. It could be that once you have your inspection, that hey, there are some defects that maybe the seller didn't know about. Maybe, hey, look, there's a problem with the roof, or the furnace is on its last legs, or it's improperly vented, so you're getting carbon monoxide kind of seeping, and that needs to be replaced. Or a lot of times what will happen is they'll want GCFI outlets. Those are those little breaker outlets, any place that you have an outlet that's around water. Or sometimes maybe the homeowner would have done his own electrical stuff and has maybe reversed the polarities on something, and so that wants to be fixed. Those are all common things which are easily fixable. And so once you have your inspection report, or your inspection, the inspector will send a report to you and your attorney, which you'll go over. Now, there might be a bunch of things, broken window, or maybe the window is one of those highfalutin windows that has gas in the middle and it's cracked, and so the gas is no longer in there, and those are expensive kind of things. And so you can request that those things either be repaired or replaced. I always ask that they be repaired or replaced by a licensed, bonded, and insured craftsman, so that it's not the homeowner doing something. Hey, I want to make sure that it's done and that you have a receipt for everything else.
You can also ask for a credit in lieu of that, correct?
In lieu of that, you absolutely can. Now, the danger with that, now, first, under the contract, anything that works for the purpose for which it was created is technically not subject to the inspections provision. However, remember I said for the attorney review, you can seek to modify anything except purchase price. So, when I get that, it's like, oh, wait a minute. I always do it under those two provisions, because it's like, all right, that might be true under the inspections, but I'm asking also under the attorney review.
Right.
The seller doesn't have to repair it or replace it, or even give you a credit. It depends on what it is, how much it is, how bad they want to sell the property. So, now this is where you get into that kind of caveat where it could be an offer, counter offer. Fortunately, the multi-board contract, provides for 3 different scenarios in terms of making that request under the attorney review. All right. So one of them is, hey, look, the requests don't constitute a counter offer, and that's fine. However, you can make it a kind of a counter offer. It depends on which box you check. So it's really important that you have somebody who's very familiar with the.
Yeah, and this is section 11 of the multi-board real estate contract 6.1.
That's correct. And so again, it depends on which provision, and usually you want to state it in the contract, or rather in your modification letter, where, under specifically what provision, because that will dictate it. Because a lot of times people would say, hey, don't consider this a counteroffer, but it is. But again, the new contract takes care of that, so if you go under the right provision, you don't have to worry about that at all. And the seller can tell you yes, no, or whatever, and it depends on what you, the buyer, wants to do. Do you really love that piece of property? There are no two pieces of real estate that are exactly alike. So, hey, if that's the one, you have your heart set on it, and depending upon the amount it's going to take to fix or anything, you might want it. So let's just assume we've gotten through this process now. All
So
right.
we have a contract that's solid. Offer accepted. The attorney review period has either passed or it's been approved,
That's correct.
and we're moving towards a closing date.
And we're moving towards a closing date. And generally, the closing date will be provided. There's also a mortgage contingency date. And when you have that mortgage contingency date, it's a date by which you have to secure your mortgage. Now, the contract also calls for a good faith letter from the lender that basically says, hey, look, you know, you applied for a contract and everything. And I always follow the specifics of the contract. A lot of people don't do that, and it could be fatal to getting the property or not if you don't. And so,
Let's assume in this case it's a cash deal.
well, it's a cash deal, then that's fine.
there is no loan
You
to be
don't
had.
have anything worried about that, so everything is good, so you don't have to worry about the mortgage contingency. But if you did have, what you would have to do is, if you didn't have a firm written commitment for a mortgage by that time, you would have to request an extension, and those are quite common.
Okay.
So, you know, and the closing date also is, you know, a lot of people like to do it toward the end of the month for interest purposes, or for taxes and prorations. So,
Okay, let's move
know,
ahead to
just
the
depends.
closing date. Who's paying for what here? Because there's something called a RESPA or a HUD-1.
a settlement statement.
Settlement
right?
statement,
Actually,
which-
it's not called a HUD-1 or a RESPA anymore, Dave. They changed the law, and now it's not even called a closing anymore. It's called a consummation. But realistically,
Sounds like something different to me.
yeah, it is. But realistically, the consummation is the closing.
Okay.
The HUD and the RESPA is the combined or master alta statement. The difference is with
But anyway, it's part of the Real Estate
It's-
Settlement
right,
Procedures
and what
Act,
it does, right? It's got a side for the sellers and a side for the buyers. It shows this is all the money and this is all of the credits that the seller has, and this is all the credits that the buyer has. Okay, so let's talk about some of those credits. Let's talk about,
Yeah.
for example, real estate taxes. Real estate taxes are paid in arrears, and there's a place in here for a percentage. So it'll be the seller wants it based upon a 0% of the ascertainable tax bill. Because again, I said you pay in arrears.
Right.
Taxes you're paying in June here are going to be for last year. Okay.
And the buyer wants
and the buyer
115%.
wants, well, the buyer wants 110%. Generally, it's 105%. You also want to make very clear and certain, and this is one of those modification provisions, all right, it's also, I believe, in the contract, where it tells you that there's no special assessment, so that, hey, you're not on a senior freeze, now all of a sudden, boy, I'm going to get whacked up for all of the stuff, because if that's the case, hey, I want to make sure that you pay that because they're your responsibility. But in any event, if we don't have to worry about that, generally 105%, because do taxes ever go down, Dave?
Not to my knowledge.
Where do they go? Do they stay the same?
No.
No, they go up. And so that's why you want to have that. And so the buyer will get a credit after the prorations because, again, when the buyer pays taxes, it's going to be for when the seller was there the previous year. So he's going to get that plus some. Also going to get credits and prorations for various things. If, for example, there was a deal for the modification that, hey, instead of fixing something, you're going to get some money on it. Okay, that should be and would be reflective. The real estate commission, it was not going to go on your side, it's going to go on the seller's side. That's going to reflect what that is. Then there are title fees. I'm a title agent as well, and the title is what the title companies research to provide you with title insurance so that you have good title. So hey, making sure what you're selling me actually belongs to you to sell me, and there are no defects.
Making sure it's marketable title.
It's marketable title. And so there's seller's charges and there are buyer's charges. Okay.
What's the breakdown on that,
the breakdown?
roughly?
Well, it costs the seller more for what those charges are. It depends on the price of the real estate. It also depends on other things. For example, the for things or the buyer to record things because
Right.
they send it to the recorder's office. There's going to be payoff. There's going to be interest that has to be calculated.
That's a form of notice, right, when it's recorded?
Right, to other people that, so hey, listen, so look, here, now ownership has changed. The old mortgage has been released because I paid for it, so that gets paid off. Any liens on the property that have been uncovered by the title search have to be dealt with and taken care of, and that's part of the marketable title.
Talk about the deed, the warranty deed. What does this mean for the new owner or the buyer?
Well, it's essentially your title, the warranty deed. So it's like a title to the car. So It's not exactly yours because much like a car, you have payments. So even though the warranty deed says, hey, look, I'm the seller, I am vesting absolutely everything, every interest to you, and it's yours. However, now that property is going to be subject to a mortgage.
Correct.
So the mortgagee is going to be the lender. They're extending the mortgage, and the mortgagor is going to be the homeowner,
the buyer.
Paying it right. The buyer paying it back. There's a mortgage and there's a note. The note is your promise to pay on the house, on the loan that you get, and the mortgage is secured by the property itself, so they can come in and foreclose. Obviously, they'll come in and they'll do both if there's an issue with that.
And the note is actually a negotiable instrument, so if you sign up with one bank, they might have the ability to sell that to another bank, so you might wind up paying a different mortgage company over the course of your loan, correct?
That's correct, and that happens quite often. In fact, sometimes that even happens at the closing table. There's a document from lender that says that. Or sometimes what they'll do is they'll assign the right to service the loan to a different company.
Yeah. A couple other quick
that'll
things.
be
If
there
it's
too.
a VA loan,
Yep.
the VA guarantees the loan. If it's an FHA loan, then it assures or insures the loan. So the
Right,
VA
so-
guarantees the loan, the FHA insures the loan. These are important things.
So either way, the buyer is going to be protected. Also,
Correct.
has to do with the amount of money that you can borrow on it. And of course, if it's FHA, in terms of any inspections or anything like that, it's going to have to be corrected. Otherwise, there's not going to be a mortgage. But you said this was a cash deal
Right.
in our example. So, but again, if it was FHA, then boy, they're going to have to. If they want to sell it and they want to close a deal, they're going to have to take care of those things. So now at the closing, you get all those things together. There's also a survey that the seller's responsible for purchasing, and generally it's a stake survey, so you could see the boundary lines of your property. It's always nice to have an idea kind of where that is, and the survey has to be within 6 months from from the date of closing. So generally, it's pretty close. And then so what happens is your attorney will look and see to make sure that there are no encroachments. An encroachment sometimes could be a fence that's over the property line. Your property, is, hey, your fence is on somebody else's property, or maybe it's a shed or something of that nature. And then a lot of times what can happen is the insurance company can what they call insure over in case there's an issue. They'll take care of it. But you want to make sure that you have that and put that with all of your closing docs. Generally, the attorney will take one as well, so he'll have one in his file too.
Okay. Let's go in detail on the one disclosure that comes up the most in litigation, which is the real property disclosure, residential real property
Oh, yeah.
disclosure report. You're basically asking, or the seller is providing you information about the condition of the property, whether there's been any flooding, whether there's been any structural damage, and it really puts the burden on the seller not only to be truthful, to be forthcoming, because if they hide something here, this could be the basis for ongoing litigation after the sale, correct?
Yeah, and I know you're familiar with that, Dave. I am, in terms of doing litigation relating to the property disclosure.
Yeah, because there's things in an inspection that cannot be discovered, such as future water damage.
Well, what's going to happen is if one of the things you're saying is that, hey, listen, there was never, we never had a flood. Okay, and the inspector is not going to rip off the drywall and look at anything. I mean, he's going to try doing a thorough inspection. So maybe you're redoing the basement. And guess what, Dave? You get ready to pull the drywall out and there's mold behind there. How does mold happen, Dave?
Exactly.
And then there are maybe water lines or something like that, and you could see those kinds of things. But
And if it was disclosed, it could have been remedied
it
before
could have been
the sale.
remedied before. That might have been part of the inspection or attorney review provision. Also, in the disclosure, if the problem has been abated and you have fixed it, generally the seller doesn't have to disclose it.
Okay.
My feeling is, again, hey, better safe than sorry here. You could disclose it. Sometimes realtors will tell you, hey, you don't need to do that, and technically they're right. Yeah. But do you want to invite that kind of litigation? Believe me, it's not something you don't have insurance for that. You're going to pay an attorney to defend that action, and it's going to cost you so much an hour to be able to do that. And believe me, litigation is expensive. Yeah. You just want to get able to move and go into your new house, wherever you're going, and kind of enjoy that. But it's very important to look at that and to really, really, from again, our perspective, we're the buyers, okay? So you only know what the seller has told you. But from a seller's perspective, hey, you know what? You don't want to have to deal with this later on as it comes.
Okay. There's also, caveat emptor, the buyer does have to
Yeah, but
beware
not,
as well in certain areas.
Not when you've made a disclosure. When you're
Right.
telling me and you're making a specific disclosure, then there's going to be a problem for you. Okay, that's not what was intended in terms of doing. That's why you have the disclosures, because you're buying a I don't know, $250,000, $500,000 home. You're spending a lot of money. You're going to be on the hook.
We got a few minutes left. Let's talk about the possession escrow, where someone sells the property, but they're not leaving exactly on the closing date. Talk to that a little bit, please.
That happens a lot of times when somebody is maybe haven't moved, or maybe they're moving out of state or something else, and that's negotiated in the attorney's review provision as well. What will happen is at the closing, a certain amount will be held back by the title company to ensure not only the payment of whatever rent that you've decided to pay, and generally it will be more than enough to compensate the buyer for whatever his new mortgage and everything else is going to be, but also to ensure that there is no damage to the property when you move. So if there's an issue and there's a problem, okay, the money's there and it gets held back. Now, if everything is good, there's no problem, and they're out on time, then hey, the buyers, which are the new homeowners, will sign off on it, and the other parties sign off it, and they'll get their money, and that'll be the end of that.
What if the seller takes something out of the house that was technically attached and disclosed in the contract as something that was staying? What do you do in that scenario?
Well, I will tell you that, if we're talking a possession, because there's two different scenarios for that. Generally, there's a walkthrough. You'll do a walkthrough with your realtor the day before the closing.
The chandelier was there during the walkthrough. It wasn't there when you closed.
If it's not there, then there is going to be an issue, because anything that's generally attached is part of the real estate, and it will say in the contract, there are certain boxes, I believe on the first page that you check, that you're keeping all vegetation, which I always find hilarious. It's like, okay, gee, I'm gonna dig up the tree. I mean, I don't know, or the tomato plants or something, but okay, window coverings, the fans, the air conditioner, all that stuff. And then, sometimes it'll say that it specifically doesn't include A, B, or C, whatever that might be, okay? So then, obviously, that's a breach of that contract and you didn't know about it, but here's something to consider too. What's the cost of that chandelier, okay? Now that's happened. Actually, what's happened kind of maybe more frequently than that is not that they've taken something, but they've switched it.
Right.
So it's not the same refrigerator that you saw. It's a different one of far less value.
Yeah. I do know a case where they took the sump pump.
Yeah.
They took it with them. They wanted to bring it to their new place.
Which is
ridiculous.
It really is for for what a sump pump costs and what you're going to do. And again, the sump pump is you got to keep the water out of the basement.
Well, luckily the new owner discovered it before
Yeah.
they had to.
Yeah.
But anyway, Jesse, the real estate transaction, as we wrap up here, it's complex. You want to have your team together. You want to have a good attorney. You want to have a good broker, and that will ensure a better than not smooth transition.
That's exactly correct. I want to also address something, because we talk a lot about real estate in divorce and all that too. So hey, if you have a situation where that's happening, you know what? One person might buy the other person out, or you might sell it together. That's also something you need to watch.
Thanks, Jesse. We'll see you next time on Legal Action. Take care.